During and after the ethnic cleansing in Nagorno-Karabakh by Azerbaijan, we witnessed an avalanche, a build-up of interstate claims and counterclaims in international courts, the European Court of Human Rights, as well as International Court of Justice, widely known as the Hague Court. In this program, the legal representative of Armenia, Yerevan Kirakosyan, will dust off the cases resting on ECHR and ICJ draws for a while now. Mr. Kirakosyan, thank you for this opportunity.
Thank you.
We always expect hope on the 31st of December, but in the hearts of dozens of Armenian families, hope can only be reinstilled if their brothers, if their fathers and sons return from Azerbaijan. As we all know, dozens of Armenian prisoners of war have been illegally detained and are being illegally tried by Baku courts. What is your message to the international community when it comes to the prisoners of war?
Thank you for this opportunity. For the prisoners of war, for those who are being illegally kept by Azerbaijan, Arna, to frame the message, maybe we should start a little bit describing what steps have been taken so far by the Republic of Armenia in this regard. We have been very consistently raising the issue about the captives before the International Court of Justice and the European Court of Human Rights, with the purpose of securing their rights under the respective treaties. I mean, the European Convention of Human Rights and also the Convention on Elimination of All Forms of Racial Discrimination. The ultimate purpose, of course, is the release and repatriation of the Armenian captives. I would describe them captives because there are also civilians among them. The message is maybe to ensure or to have to increase the pressure over Azerbaijan to facilitate or to somehow expedite the repatriation of the Armenian POWs, because unfortunately the issue of repatriation and release is beyond the scope of the courts. We have attempted to request the courts, both courts, to immediately indicate or order Azerbaijan to release. But unfortunately, in both cases, we have been rejected by the courts with different justifications, but that's what it is. And mostly the issue, specifically release of the prisoners of war and civilian captives, is more of a political topic for discussion.
You generate the tools, the legal tools by which politics should hopefully bring them back home.
True, yeah.
Out of the 17 points of the peace treaty draft, 2 are not agreed upon. One of those is that Baku requires the withdrawal of international interstate claims. Does this imply that our cases in international courts are very strong, and if we move forward, we win?
It's a good point to start, actually. Indeed, our positions and our cases are arguments put forward by the Armenian legal team in both international courts. The European Court of Human Rights and the International Court of Justice are quite convincing and are very strong. And especially this indication and this assessment is more or less based on the recent judgments by the court, which were published on November 12, 2024, about the preliminary objections of the Republic of Armenia and also of the Republic of Azerbaijan in both cases. So we had 2 judgments about the preliminary objections dealing with the jurisdictional and admissibility issues of both cases. The judgments by the International Court of Justice in the case concerning the application of the Convention on Elimination of All Forms of Racial Discrimination. And in those judgments, specifically by the judgment of the case Armenia versus Azerbaijan, most of the Armenia's claims were reaffirmed, falling squarely within the jurisdiction, the ratione materia jurisdiction of the convention, and also the fact that Armenia has fulfilled the negotiation requirement, for example, for bringing the claims to the court, And also, on the other hand, we have the Azerbaijani claims substantially reduced as a result of this judgment, because most of the Azerbaijani claims were considered to be outside the ratione tempore jurisdiction of the court, meaning the jurisdiction in time, and also some claims that have been put forward by Azerbaijan have been declared to be outside the material scope of the convention, meaning outside the ratione materia jurisdiction, which means that the convention is not applicable in the claims that Azerbaijan purports or alleges. So this means that, which we have been asserting actually over and over again in the past couple of years, throughout during the different hearings on provisional measures, the court has confirmed. So we have now the situation, which now we're entering the merits phase of the case, and where now the court has issued orders assigning 1 year time limit for both countries to present counter memorials in each case. So we're now working in our counter memorial, and in the case concerning the Azerbaijan versus Armenia case, and we'll be receiving also the counter memorial in Armenia versus Azerbaijan case from Azerbaijan. And this is the meritorious, so this is going to be the merits phase of the case, where the court will be dealing more with the substantive matters, so already behind what is left after these jurisdictional judgments. So yes, I would say Armenia's positions are quite strong, and as based on also Azerbaijan's positions, and as we have been repeating that over and over again, the case brought by Azerbaijan at the International Court of Justice is just a mirroring case, an attempt also to deflect attention from its own violations, so which is the reality. Yeah.
So those cases by Azerbaijan against Armenia do not hold water?
No, they are not, and I think that we have also one case, two cases actually, before the European Court of Human Rights by Azerbaijan against Armenia, which is being considered by the court in the formation of the Grand Chamber, the first application. And I think all of the applications, and the first application, the first case, which has been presented to the court back in 2021, early 2021, January the 15th, and which relates partially to the events that happened in the beginning of 90s. And a part of it relates to the events of July 2020 and also the 44-day war. And I think at least the parts, the claims relating to the events that happened in the early 1990s will be, based on the case law of the European Court of Human Rights, should be considered, we assume, inadmissible. We assume so. That's why I don't want to jump forward, because that's the prerogative of the court to come up with the decisions. But my conclusion is based on the precedent and jurisdiction of the court itself. There is a judgment, not a judgment, a decision by the court, which came out, I think, in early 2021, Samadov versus Armenia, which was describing and discussing the issue of presenting claims without undue delay with regard to violations, the continuing nature of violations that happened in the early 1990s, and which, according to that judgment, this period which the court was admitting this kind of claims was open from the moment when two countries became members of the Convention or the Council of Europe, and until around 2005 and 6, those periods, years 2005 and 6. And we know that quite large number of applications have been presented from both sides against each country. Now they're pending before the court. I'm sure that from these cases we have two judgments against Armenia, and one against Armenia, the other against Azerbaijan. The one against Armenia is Chiragov and others versus Armenia. That's the judgment relates to Azerbaijanis, the property rights of Azerbaijanis from the Latvian region. And the other is Sargsian versus Azerbaijan, which is the rights of the property rights and right to family life of the Armenians that have been forcibly displaced from the Shamian region. So those two judgments are the exemplary cases taken out of this hundreds of applications, and now, but still the other couple of hundreds of applications are pending before both countries at the European Court of Human Rights, which relates to the events that of the early 1990s.
4 interstate complaints in ECHR and ICJ against Azerbaijan and mirror claims against Armenia. It is obvious that there is more underwater. These claims flow back into the racial hatred that, although both nations have decade-long war scars to draw from, official Baku incites and provokes on state level out of political expediency to keep power. Suffice it to say that peace builders in Azerbaijan find themselves behind the bars. International courts are often criticized for justly or unjustly for not having mechanisms of enforcement. In this context, the Prime Minister shows a willingness to concession on the legal front once, quote, real peace is achieved, unquote. Should justice, considering what I have already mentioned in connection or in relation with the imperfect mechanisms of enforcement of international courts, be sacrificed to peace?
That's a good question, but let's start maybe a little bit reshaping that question or approaching to that question from different angles. What is peace? I mean, why are we contradicting peace with justice? I wouldn't put the contradiction between these two. I would even rather argue that peace, a durable peace, is possible achieving through the justice. And
yes,
why?
But Baku says, drop justice, you will get peace instead.
Yeah, but that's threatening. It sounds more like threatening and intimidating, not a real or a sincere statement that is being made. And I think the motives behind it are not, I wouldn't say that, are very sincere. And I think the motives of saying that can be or not characterized in many different ways, but maybe the last thing that I would think is maybe peace. Why am I saying this? One of the maybe core or very important answers to this question is can be drawn out from the preamble of one of the conventions based on which Armenia has cases against Azerbaijan. That's the Convention on the Elimination of All Forms of Racial Discrimination, which in its preamble has a very specific provision with a very specific aim, which emphasizes that the elimination of the racial discrimination among nations and different nationalities, the existence of this animosity between ethnicities and nations is the cause for war. And the idea of this convention is exactly prevention of peace, because when
cutting the grass at its roots.
Yeah, when you are putting the seeds of hatred and animosity towards specific group, and you are doing it on an institutional basis, and that's not actually mean that you are preparing for peace. Just on the contrary, as we saw on the example of the 44-day war, which was very much the result of this. And also not only the war itself, but also the heinous acts perpetrated during the wartime. I mean, the war crimes and crimes against humanity and other grave breaches that happened are very directly linked with the propagation of hate and hatred. And that's why this kind of institutionalized spewing of hatred is giving birth to war, to an aggressive war, and it's giving birth to an aggressive or a perpetration of crimes against humanity, war crimes. So that's why I truly believe that this the proceedings that we have at the international courts are a way of peacefully resolve the disputes between the two countries that we have. And I think we should not pretend, or we cannot pretend that there is not any dispute between the two countries, because we have a history of decades long, or I think maybe even not a decade, maybe 100 years long, or rooted conflict. Which a very complex conflict, and I don't think that it will be possible to set the facts straight without the process of adjudication, because the process of adjudication is not only about remedying things, it's not only about remedying rights, it's not only protecting the rights of those who are the victims of violations, but also there are a process for establishing or establishing the facts as they are, not allowing the other party to manipulate with the aggressive propaganda of their own narrative, so that they can have impact on political or geopolitics and political decision making internationally. So, like in the courts, so therefore the court's proceedings are more than just a way of claiming compensation or redress for violations that have been that have taken place.
We have another tool that has not been used yet. Armenia recently became a member of the International Criminal Court by ratifying the Rome Statute. If this new legal weapon is used, Baku military and political leadership could go to prison for war crimes. Yeah. Do you intend to use this tool anytime soon?
I'm not going to. The decision actually for if there will be a decision for using the tool, I'm sure that the public will know about the decision of using the tool. I don't want to make any speculations at this point, but the thing is that, of course, Armenia ratified the ICC statute, the Rome Statute of the International Criminal Court, with the purpose of preventing crimes that fall under the jurisdiction of the ICC to be committed on the Armenian soil. And that's very straightforward. I think that was one of the reasons that we were ratifying the statute. Of course, ratification.
I hope it doesn't mean that whatever happened before the ratification goes unpunished.
I don't think.
How it's
no, I don't. No, I don't think so. I don't think that will happen. But in any case, Armenia has accumulated. We have accumulated a very considerable amount of evidence which relates to the events that happened in the past years. I mean, like starting from 2020 war, 44-day war, going onwards until, I mean, the last year, the forcible displacement of the entire Armenian population from Nagorno-Karabakh, and also other events that are very concerning on war crimes which have been committed on Armenian territory a couple of years ago, not going too far. And all those evidences are there, and I think, again, the tool is there, and we are a part of the family of the court, and we actually have participated in the Assembly of States Parties just in December, earlier this month, and we are very eager to engage with other countries, members of the court, in strengthening the institution as itself. And by the way, just returning to the last question that we're discussing about the mechanism of enforcement of the judgments or the decisions of the court, might be the thing that I do not think that the decisions or the judgments of the courts are completely without any enforcement mechanism. I'm not the one to think that way, and I don't think that the fact that, for example, we're not seeing in Azerbaijan's movements or behavior a complete change or complete adherence to the decisions of the court, I mean the orders of the International Court of Justice, that would mean that there is no effect of those orders at all. I don't think so. I just think, on the contrary, I think there is an effect on the behavior of every country, including Azerbaijan. And I do think that this effect is positively, we see that positive, and I understand it very well that the issues, for example, when we are speaking about the the case pending before the International Court of Justice, which deals with the elimination of racial discrimination. That's not a very easy thing to do, because when we're speaking about the racial discrimination that has been propagated in a society with an institutional or in a setting in a very systematized way and in a very concerted and on a organized manner, it would be very naive to think and hope that this will go away by just clicking the button or a finger. It's a very deeply, unfortunately, I'm saying this, very unfortunately, it's very deeply seated and deeply rooted phenomenon, because we're speaking about unfortunately, we're speaking about not only the spewing of hate speech by the leaders of the country, the decision makers, or the civil society, but also we're speaking about the educational system itself.
Yes.
It is being ingrained from the very early years of children, etc. And that's why I think it is that also really reinforces the idea of why we do need this kind of proceedings in the first place, because these proceedings are very much important to, I think, from the security perspective, are very crucial tool, and including also the ICC tool. And I think it is very also remarkable, maybe not remarkable, worthily mentioning, I would say, that including the representatives of Azerbaijan are speaking about the Armenians joining to the International Criminal Court, viewing that as an impediment to peace, which sounds a little bit odd. I think that also speaks volumes about their
intentions.
Effect, intentions, plus also the volumes about the effect of the courts. Yeah.
Thank you one more time.
Thank you very much.
How this legal saga ends is up to the judges at ECHR and ICJ. I pray that impartial judgment shines through the cacophony of unresolved interstate political sentiments, to use a euphemism. I do certainly hope justice takes over.